Welcome to InfoSec Court, where we put on trial the misdeeds of cybersecurity in an informative, educational, and entertaining way. Please, feel free to throw eggs, ask for cheeseburgers, or just sit there and watch as we the people take the power of cybersecurity back.
We present the truth. We present the facts. Welcome to InfoSec Court, where the good, the bad, and the ugly are on trial. Here is our bailiff,
Michael
and our
Thorson.
press director, Nick Espinoza. Let's welcome tonight's guest judge, guest plaintiff, and guest defendant. Bailiff, please give us tonight's trial information.
Today we hear case number 24025-01, We the People versus Google and OpenAI regarding the alleged copyright violations of their respective tools. For the plaintiff, we have Ed Gibbs. For the defense, we have Aaron Birnbaum and Joshua Copeland, who should be joining us very shortly. He's giving another talk at the moment. Double booked, busy guy. And please rise only if you're wearing pants for the Honorable Judge Debbie Reynolds.
Debbie, we can't hear you.
She's muted.
Sorry, can you hear me now?
Yes.
Okay, thank you. Thank you so much, Michael. So for the plaintiff, we have Ed Gibbs, We the People. Ed, are you ready to make your opening arguments?
Sure. Yes, Your Honor. Yes, Your Honor. It's a little late in the afternoon here, but that's okay. Are you ready to proceed? I can proceed. So, ladies and gentlemen of the jury, Your Honor, esteemed members of the court, today I stand before y'all, please pardon my southern New Orleans accent, to represent the people against titans of innovation and technology. There's no doubt that these two companies, specifically in the context of their groundbreaking AI systems known as ChatGPT and Bard, these two famous entities are not merely companies. There's no dispute they are pioneers at the forefront of artificial intelligence revolution, but that does not excuse their behavior. In this case, we're going to demonstrate direct trademark violations, and it's critical to understand, I guess, the nature of these technologies as we move forward and what they've done to excuse their behavior and the damage that these two companies have done and the amount of information that has been stolen. And make no mistake when I say stolen, for their sole purpose of making money. These AI technologies that were developed, sure, they're distinct in architecture, functionality, application, and in some ways, they produce a massive amount of data that they can derive. But these are mere replicas, imitations, for the sole purpose of pleasing nothing more than the shareholders of their company. They're not original creations born out of vision to advance human potential through technology and availability of information. That's a myth. These things are already in the public domain. These companies are nothing more than web scraping, collecting data for the sole purpose of making money. Throughout the trial, we'll demonstrate that, and the perceived similarities between these products and other products that are coming along that are using artificial intelligence. And the core of this rests on the uniqueness and the originality of these AI systems. But is there really originality? We will present evidence showing that these AI technologies were misrepresenting, deceitful, misleading in every way possible, and that their statement, what is the common one they like to say? Our commitment to innovation and excellence. These are simply, like I said, data scrapers scouring for any and all data that they can resell. Moreover, we will address the principles of trademark law, emphasizing that a violation to occur, there must be a likelihood of confusion among customers regarding the source of these products. But there's no confusion because nowhere do these systems divulge where they learned the data from. They don't show you, for example, the source in which they derived or how they derived their data. There's no audit data or anything like that that you can request. So to a consumer, this looks like original data. They don't show credits. They don't show anything. And we'll provide clear evidence that consumers cannot easily distinguish between the AI offerings, either by Google AI, OpenAI, or anyone else, where these entities do their unique characteristics and branding to hide these facts. Ladies and gentlemen, as we proceed with this case, I urge you to consider the evidence that we will be presenting. We are confident that once you heard our arguments and examined the evidence, you will find that OpenAI and Google have not only defied the legal confines of trademark law, but have also contributed negatively and uniquely to the field of artificial intelligence, giving it a bad name. Thank you.
Excellent, thank you. Now, who wants to speak on behalf or answer on the behalf of Google?
That'd be me, Your Honor.
All right, go for it.
I think that Mr. Gibbs has made some excellent points. I personally disagree with most of them, however. You talk about these huge conglomerates that are all about the dollar, and you have to remember that my clients started from a garage. They use their intellect, their brain power to make incredible products and services. They're really the victims here because people see these big companies with big numbers and they want to sue them because they figure they'll just settle, throw some money at them, and then we'll be fine. The key thing that Mr. Gibbs fails to address, number one, is the fair use doctrine, and which allowed for limited use of copyrighted materials without permission for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, to quote the statute. The other issue that we have to talk about today is the lack of substantial similarity, because you can't tell me a New York Times article and a large language model are anywhere near the same thing. The suit is meritless. These are incredible programs that are benefiting millions, billions of people, dare I say, worldwide. And people see dollar signs and they come after whoever has it. I will gladly refute any of Mr. Gibbs' claims and stick to our defense of the fair use doctrine and lack of substantial similarity. Thank you, Your Honor.
Excellent. So who do we have speaking for OpenAI?
I'm also representing OpenAI and Google, Your Honor.
All right, go for it.
My co-counsel, unfortunately, was delayed. I believe he was pulling orphans out of a burning building. However, he has let me know that what I said is what he would say as well.
All right. So basically, you're claiming fair use for Google and both OpenAI, and that's your defense?
Yes, Your Honor.
So please, Ed Burns, do you want to respond to that?
How many times have we heard, oh, this person started a company out of a garage, or, this person started a company out of the back of their car? What does that matter? Whether you started with $5 million, $10 million, or $1, it doesn't matter. Fair use doesn't mean or give you any authority or privilege to go out and steal someone's information. Now,
Objection, Your Honor.
Your Honor.
Keep going, Ed.
Sure. Ejection, I see that. But, when we look at this, now you look at fair use. Okay, now what is fair use? Now, in this case, here I have a picture of, guess what? The Bean in Chicago, right? It's a common landmark. It's beautiful. Everybody loves looking at it. I love Chicago. I used to live in Chicago. But I framed it and added the Bean, Chicago, as well as, hey, AI Studios. Now, I'm going to go put this in my gallery and I'm going to sell it and make money. Now, does that give me the privilege to say that that is my picture of something?
You're selling it.
I'm selling it, absolutely. And AI and Microsoft are doing the same thing, and Google. They are rewrapping the data and selling it. Is it their data? No, it's not.
What do you say to that?
Well, Your Honor, I think he makes a very interesting point. However, if he is selling his project that he derived from someone else's intellectual property that is not in the common arena, which this is, if he's taking money for that and it's not his, I believe that's theft. And I'm sure that's not what Mr. Gibbs meant to say. What I think he meant to say is he transformed that picture with border and caption and derived a new creation out of it, which is legally his, that he could sell. However, he's absolutely making my point for me. That is fair use. That is exactly what my clients are doing. They are taking data, they are manipulating it, changing it, using it in a different way than it was intended, and they're using it for the better of humanity.
Yeah, see, Your Honor, there's that statement again, for the better of humanity. What has the better of humanity got to benefit from this, right? Access to data is always there. If I want to go read the news, I'll go to CNN.com or Fox News or MSNBC, whatever your favorite choice is. But it's there and I know where to go. Now I can go to one website, these chat engines, GTP engines, and then just type in anything I want, and it goes out and it collects all this information for me, makes a statement and redisplays it, and all of a sudden it's there. But the fact that I took a picture out of a public domain and reframed it, is that really my original work of art? The art is the Bean, not me.
Objection, Your Honor. Relevance.
So Aaron, I'm going to make an analogy, and you tell me whether you think it works or not in this context. So if we were neighbors, and I had a rake in my yard, and then you took it and put it in your yard, does it make it your rake?
Absolutely not.
Exactly. It's not your rake. This is, even though you may put your name on it, you may repackage it, you may put a fork on the end of it and say, hey, this is a new kind of rake. It's got 4 prongs on it. Whatever you want to do, you can do whatever you want, but it's still the rake out of the judge's yard.
It's a tangible item. It's a physical item that exists in reality that can be touched. You cannot touch electronic data.
But
it's
Your Honor,
not a fair apples to apples, oranges to oranges comparison.
in that case, people's lives can be touched.
Absolutely.
Money can be touched, right?
Currency can be touched. Yes.
Currency can be touched, yes. So the impact of this, don't get me wrong. I love AI. I use AI every day, right? And it's a wonderful tool. I look at how to write Excel functions and do all kind of things. I have it write code for me. That's wonderful. That's original. But when it goes out and collects all this information from all the universities and everywhere else, these people's hard work that they would love to get credit for, there's no credit in this. It doesn't even a lot of times reference where it learned these things. There's no link or reference saying, hey, you know what? We had a case recently where, the president of Harvard was accused of plagiarism.
This case isn't about credit, though.
It's not about credit,
That's
but
not
it
it
leads
at all.
to credit. right? I would be okay if Google and Microsoft say, hey, you know what? I learned this from this website. I learned it from this website and things. Try doing that. It won't give it to you.
I fail to see the reason. If you want to file a suit against us for failure to attribute to someone, that's a completely different matter. Today, we're talking about the copyright infringement
Right.
regulation.
Exactly. Copyright. Well, what's the difference between that and plagiarism without a reference?
I say you're speaking apples to apples to oranges. You're not equivocating what the problem here is. The problem here is you define it as this hard work from these researchers that has been done, which has minimal tangible financial value, is being used to train data sets. For, if I might add, OpenAI is a nonprofit, so they're not making billions of dollars. Google has a lot of different companies. Alphabet has a lot of different organizations.
They do.
They're able to use the AI to make their products and services better for people. For example, pharmacy companies are using AI to create cures for cancer, to grow limbs, to grow organs. And they're able to speed research up for horrible diseases. Without AI, they could not have done it in anywhere near the time that they have been able to achieve it. I believe the latest statistic I heard was something that 1 year of having AI for researchers in the medical field has advanced medicine 10 years. Is a medical textbook something that you think should not be shared?
No, absolutely. A medical textbook, that's fine. You know, let's break it down to a simpler term, right? You want to perform calculations, you go out and get a calculator or whatever, you know, use your computer, use spreadsheets, things like that. That's fine. You derive your own work. But for the advancement of yourself and these companies that are using AI for the advancement of, you know, generating a profit on their own, sure, AI, you know, these companies are nonprofit, as you mentioned, but they do charge a subscription.
They have operating costs. It's called business.
Absolutely. It's a business. And what a business is in, they're not community service. They're not there for the betterment of, you know, everybody at will for free.
So Ed, I want your thoughts on data scraping. I know this has been a controversial issue in terms of the legality of that. But tell me about that, because this is basically what's happening in a way with these companies.
Right. So data scraping is an automated way of going out to the internet and collecting information from various websites and correlating it, normalizing it, and, you know, learning from it, essentially. And these companies have put their data out there in the public domain. Now, you know, Aaron, I know you're going to be shocked to hear this.
If it's in the public domain, they're not taking it or stealing it or using it.
Exactly.
It's in the public domain.
And I agree with you. There are things in the public domain I'm okay with. You know, if one of the news organizations publishes an article and they don't have a subscription tied to it, or it's not gated or anything like that, fine, go ahead and grab it. But the problem is, you know, there are institutions out there that are bound to share information. And I'm saying is trademark. When something's trademarked, give credit where credit's due, right? There's no way to learn from OpenAI where it learned this information. And how do you audit it? You can't. So if a person in the company publishes something and OpenAI has access to it, and it's proprietary information, we're going to see this a lot. You know, that intellectual property escaped through AI. Then who's accountable if OpenAI has no way to say, well, I learned it from, you know, some company over here, and yeah, sure, they didn't secure it properly, but I learned it anyway. Does that make it okay?
No. Are you familiar with the concept of mixing music, where you take a song and add a different drum beat to the background?
Sure, yeah, DJs do it all the time.
DJs do it all the time, and they produce records and they sell those records.
That's right. Are they original works of art? No.
That's not the point, though.
And they're supposed to credit the original artist, and the artist earns money from that.
That's right. The original artist has the right to sue on the behalf if they don't. And a lot of times if they don't pay a royalty.
If we're talking about data, the owner of the data or the custodian of the data has to establish clear ownership or appropriate usage rights. Has that been done by the New York Times prior to this lawsuit?
Well, the New York Times is the newspaper record in the U.S. So I think people know who the New York Times is. They understand where that information comes from. Their
What if they-
journalism. They pay people to make these articles and put them out into the public. So I think to some extent they should have some type of say about how their data is used.
I agree they should, but do they? Can you show it to me?
So how does that benefit anyone?
How does what benefit what? I don't
Well,
understand the question.
I'm saying, let's say that the New York Times, if OpenAI has the ability or Google has the ability to learn everything New York Times publishes, why do I need to go to New York Times? Where's their money? Where's the interest in the intellectual property they produce?
This isn't a discussion about the dying newspaper industry. This is a
No, I
discussion
agree, but
about
then
copyright.
how does any company survive that?
That's not the topic of this discussion. I don't see the relevance in that.
I guess, are we over? Are you all ready for the next stage?
Sure.
Sure.
All right. I think we want to take a recess. No?
I love recess. It's my favorite
Same here.
subject in school.
Sander?
Yeah.
All right. So I guess I'll give the verdict. So thank you to both sides for being able to give your thoughts. I think this will be an issue that will be talked about a lot in a lot of different courts in terms of what they think. For this session, I think that Google and OpenAI have not convinced me that they are cognizant of the rights of people who produce some of this information. So just because information is in a digital format, you can't reach out and touch it. Doesn't mean that you can do whatever you want with it. I know we have schizophrenic laws within the US around this where digital information or information that isn't in someone's physical possession is treated differently because of the third-party doctrine. So to me, I think that's a gap or a loophole that needs to be addressed. In addition to fair use, there are issues here around data scraping. Who can scrape data? What can they do with data? Are people harmed? I think that's another gray area in this situation. So I think the New York Times is saying, hey, we're harmed because you're taking information from us where we've invested money and time and even being able to produce this where other companies are using it. So I think these companies play in that gray area that hasn't yet been fully filled in. So I think people are looking to the courts to be able to fill in these gaps and try to create some precedent. But really what we need are laws that more easily align digital information with almost like physical information. So I think that's my verdict. I'm going to rule in favor of the people in this particular case. And thank you so much.
Thank you, Your Honor.
You're welcome. Sandor, go to the next thing.
Thank you for attending tonight's InfoSec Court. Please stick around for the final verdict with Nick Espinosa.
All right. And it's so good to be back for another season. And I absolutely love it when nothing technically goes wrong. This was absolutely perfect. But we have so much fun when we do these together. And it's always fun to just catch up with colleagues. And so honestly, though, let's dive in, because what a great and honestly, seriously relevant case here to start with. I think if anything, this really underscores the situation that the future of AI and how it gets trained has ramifications for its use, both across the entire world and long term. So before we dive into that, as always, I want to thank the following people that basically made this actually happen. First things first, our guest judge, Debbie Reynolds, the Data Diva herself, bailiff Michael Thornson, guest attorney Ed Gibbs, guest attorney Aaron Birnbaum, and Joshua Copeland. Thanks for trying. So with that, everybody else that had a hand in this, Sander Slidener, Sean Tovey, Katie Hansen, everybody, thank you so much. And of course, Fusion Cyber, who is literally doing the Cyber Lord's work, closing those employment gaps in cybersecurity, which is a big deal for us. So with that, let's just dive in. And let's talk about the situation at hand, because OpenAI, and I'm throwing Google here too, but let's focus on OpenAI for a second, because they readily admitted that they need copyrighted material in order to make their models work. And that's the crux of the situation here. So OpenAI, as you all know, maker of ChatGPT, was actually questioned by the United Kingdom's House of Lords Communications and Digital Select Committee. And yeah, I honestly think they're really going to get sued even more for copyrighted material use in the future. That's my opinion, obviously. But here's what I think they're trying to do, and Google's right alongside them. They are trying to alter or change copyright law altogether. Now, I read OpenAI's written evidence submission to the UK, and it's actually 4 pages long, and it's really interesting and telling about where this is going. So, the House of Lords Communications and Digital Select Committee asked this question in writing, and I quote, and I will not use a British accent for the record. Please, could you explain your position on the use of copyrighted works in LLM training data? What are the options for building models without using copyrighted material? Now, here's basically the interesting bits from their response, because they went on for about 4 or 5 pages or so on other questions too, and they said other things in their answers, but here's the crux of it. Here's the justification as to why copyrighted material is beyond critical to generative AIs, and strap in, because this is literally OpenAI's process for this, which I think applies to Google and everybody else. And I quote, "We believe that AI tools are at their best when they incorporate and represent the full diversity and breadth of human intelligence and experience. In order to do this, today's AI technologies require a large amount of training data and computation as models review, analyze, learn patterns and concepts that emerge from trillions of words and languages and images. OpenAI's large language models, including the models that power ChatGPT, are developed using 3 primary sources of training data. 1, information that is publicly available on the internet. 2, information that we license from third parties. And 3, information that our users or our human trainers provide." End quote. Now, here's the kicker to the entire argument that they are making, and I quote again. "Because copyright today covers virtually every sort of human expression, including blog posts, photographs, forum posts, scraps of software code, and government documents, it would be impossible to train today's leading AI models without using copyrighted material." End quote. And if you're asking, well, why is that? They answered that too. Quote, "Limiting training data to public domain books and drawings created more than a century ago might yield an interesting experiment, but would not provide AI systems that meet the needs of today's citizens." And they're right. They're absolutely right. if you think about it, how on earth, are we going to take 100-year-old data and apply it relevantly here? There wasn't even the internet back then. I mean, come on, Vanilla Ice didn't even exist, for God's sakes. So with that, they say that they comply with all copyright applicable laws, but then they say this, and I quote, "Although we believe that legally copyright law does not forbid training, we also recognize that there is still work to be done to support and empower creators. We have been industry leaders in allowing creators to express their preferences with respect to the use of their works for AI training." So how does that equate to basically saying that they want to change copyright laws without actually saying that they want to change copyright laws? Remember, they stated, and I quote again, "Copyright today covers virtually every sort of human expression, including blog posts, photographs, forum posts, scraps of software code, and government documents." And one of basically the main concerns in this particular lawsuit is that they owe a ton of compensation to actual creators. Think George R.R. Martin, who wrote Game of Thrones. Think Sarah Silverman, she's a comedian who wrote apparently a best-selling book, and a slew of others are actually suing. They have established precedent to say, "This is my work, and if you're going to use this work to create derivatives, we've got an issue there because you are literally ripping off my work." That's been adjudicated by the US Supreme Court as well. So if they can get the law changed to accommodate artificial intelligence, then they're off the hook. Remember, they formally said, and I quote, "In our training models, OpenAI complies with the requirements of all applicable laws, including copyright laws." So applicable laws, make the law not applicable, and we're good. So I do think that's their long-term goal here. And for the record, like I said, this also includes Google and any other competitor as well, because they're in that boat. And yes, they claim that synthetic data may be able to assist or even replace human creations, but training AI then gets really messy. So think about the photograph example. If you've heard that before, I take out my phone, I take a picture of something, and then somebody comes along and basically looks at the picture of my phone, pulls out their phone, takes a picture of my picture on my phone, somebody takes a picture of their picture on their phone, and you start to see the problem. Without unique human creations, it becomes rather messy because you start to really get fuzzy. And as we are dumping more and more writing and everything else into the dark web, into the web in general, with artificial intelligence, essentially AI starts training on AI, and that muddies the waters. And so that's the crux of it. They need human creation. They need copyrighted material if we're going to advance the next phase of artificial general intelligence, where they think they're going to basically, AI is going to think like humans. And if Mark Zuckerberg gets his way, he's going to be on the forefront of that. And God forbid he owns the Terminators, because that man, lordy lord. So with that, let's discuss basic security controls here. And honestly, it's really going to come down to acceptable use policies for me when it comes to the human side, because OpenAI and the Googles of the world are vacuuming up data left and right on essentially anything submitted, and on the internet, they can essentially read and use it. And so I would recommend putting in the following controls for your organization. Don't train an artificial intelligence like an OpenAI's ChatGPT or Google Bard using data from your organization. It basically can take your intellectual property. Don't share your data as well. Don't attempt to integrate third-party AI at this level, with business intelligence systems either. And don't anonymize your data, because these LLMs are really good at de-anonymizing. And so if it is needed, obviously talk to qualified professionals to make sure you're doing it securely and privacy. And so if you're using AI, just make sure you're also, and on the personal level, following these rules. Scrutinize any results. They love to lie to you. I've written articles on how I've gotten ChatGPT to lie to me in various ways, or just make stuff up. Also be aware of its limitations. AIs, like humans, can have biases or incomplete understandings of concepts. And so that's a huge issue. And then obviously make sure that you're minimizing, the use of personal data that you're giving to it. So with that, if we're talking about improvements, I think the big points in improving user training for use is a huge thing, but we also have to make sure that intellectual property and copyright laws are strengthened so that the actual creators, like the George R.R. Martins and Sarah Silvermans of the world, can enter into amicable agreements for compensation that AIs can be trained properly. This isn't going away. AI really is the future, and those that are creating unique works should be compensated fairly for it, in the same way that I can't completely rip off, a popular song and go play a Taylor Swift song and call it my own. Taylor Swift's going to sue somebody, and I'm not going to be on the end of that. But that's what we're talking about here, I think, essentially in just a similar way. So with that, as always, thank you once again to everybody that helped us. Obviously our guest judge and Data Diva, Debbie Reynolds, guest attorney, Aaron Birnbaum, Joshua Copeland, Ed Gibbs. Thank you so much. Everybody else that helped with this, Sandra Slidering, Sean Tovey, Katie Hudson, thank you so much. And of course, Fusion Cyber. Once again, I'm Nick Espinoza, and please feel free to connect to all of us on LinkedIn or follow us wherever we have stuff. And on behalf of InfoSec Court, thank you so much for watching. And remember, we're not lawyers, but we do play them on internet TV. So as always, stay vigilant, stay informed, and please stay secure. Good night, everybody.